Good evening, everybody, and welcome to another edition of the South Florida Tribune podcast. My name is Scott Morgan Roth, the Motor City Manmouth, fresh off a broadcast with Ron Swoboda of the Miracle Mets with Stuart Hack, and we talk about the second end of our doubleheader tonight. Ron, well, welcome to be back here alongside my co-host, Candy Ebling. What's going on, team?
Well, Scott, it's a pleasure to be here again. I heard you had a great broadcast, and I hope this one will come close, even though I was not on the 69 Mets.
No, but you were definitely in mind, and you were definitely in heart, for sure. So, no, it was a great broadcast. Ron Swoboda and Stuart Hack. Anytime you compare two people up that, lived in the same area, that had the same passion for the New York Mets, it was a great opportunity to bring those two on. And Stuart Hack is such a great, loyal part of our team here, that it was a show I was glad to put together, and to be able to put it back-to-back with this broadcast tonight, to me, it really feels, it's a really great feeling. So, but meanwhile, we have a great show lined up. No compete agreements. Oh, I got a few stories to tell you there. So why don't we go ahead and take over, Ron, and then we'll go along with what people should or shouldn't do in our beloved Sunshine State, considered the hotspot of COVID-19, although that's for another part of this broadcast that we probably don't want to think about anyways. Go ahead, Ron.
Well, thanks, Scott. I just felt like we talk a little bit tonight about non-compete agreements, specifically focusing on Florida for our Florida audience with the wonderful South Florida Tribune. We all pretty much know what a non-compete agreement is. People sign them every day. All kinds of jobs that you sign one. Essentially, you agree that when you leave a job, you're not going to compete against your employer, or while you're at the job, you're not going to compete against an employer. Now, Florida is a little unique in this way, is that Florida has a specific statute on point, and it's one of the most expansive statutes in our USA. It's Section 542.335 of the Florida statute, called Valid Restraints on Trade or Commerce, and that's just a fancy way of saying non-competes. So, basically, a non-compete has to be in writing and signed by the person who is going to be enforced against, which is usually the employee. Let's say you hire, a radio host, and you don't want them to compete against you after they leave such a wonderful establishment as ours and goes to, let's say, ESPN. Well, you don't want them to compete for a couple of years. You have them signed a non-compete. Now, would it be enforceable under certain conditions? Yes. There has to be what's called a legitimate business interest, meaning you can't just sign a non-compete for no reason. It has to be part of your business. It has to be a legitimate business interest. Use our little broadcaster example. You have a legitimate interest in all the time and effort and all the work that you put in getting your host going. And I know, as an aside, folks, Scott is a really good man about getting people on the air, up-and-comers, people that have been around a while, everybody. So, not that Scott has anybody signing these, but a company could have somebody sign a non-compete. There's a couple of things that it protects. A trade secret. A lot of companies have trade secret. Valuable business professional information, otherwise does not qualify as trade secret. Sometimes businesses have special processes that they use, special formulation, special customer list, that kind of thing. Another one is substantial relationships with prospective or existing customers or clients. A business sometimes takes years to get their customer list, to get the right clients, and they woo them, they take care of them, they don't want them stolen. Another issue is goodwill. Businesses build up goodwill over the years. Very important. An ongoing business practice by way of a trade name or trademark. Somebody buys a trademark, that's very important. It's very valuable. You don't want somebody using it and competing against you. Definitely not. And you have to have a certain geographic location and a certain marketing and trade area in your agreement that you want to protect. Let's say you own a small business that's, let's say, cuts lawn. You do it in one town. You can't protect it in Alaska. You just can protect it where you are. Also, specialized training. Some professions, such as radio, like Scott, has super specialized training. And once you impart that knowledge with somebody, you don't want them just using it and stealing it and going on their merry way. So, now a court will enforce these, but it will not enforce if it's not supported by a legitimate business interest, or if your business is illegal or void or unenforceable. So if you're running an illegal business, selling stolen goods, you can't have your employee sign a non-compete. That's kind of goes without saying. So let's say you have this non-compete written. Now, there are certain forms. We even have one as an example that we're going to put on the South Florida Tribune site. So anybody can take a look. It's a wonderful site, chock with information. And we'll have not only the Florida statute, but a little sample non-competition agreement. There were all kinds, but they have to have certain things in it. Now, if a court is going to enforce a suit for a non-compete, now, okay, let's say a non-compete is signed. The person that signed it breaches it, meaning they're competing. Let's say they're opening a competing business across the street. The only way to enforce it is like every other contract, you file a lawsuit. So when you file a lawsuit, you have to plead, which is plead and prove, show to the court that the contract, the restraint in the contract is reasonably necessary to protect the legitimate interests of the business, justifying the restriction. If you establish that it's a reasonably legitimate purpose, then the burden falls to the person being sued to prove that the contract is overbroad, overlong, or not otherwise reasonably necessary to protect the business interest. If it's overbroad or overlong, the court can actually what's called modify the contract to make it to comply with the law. Now, the court will determine if a restrictive covenant or a non-compete is reasonable. There are two things that has to be reasonable. It has to be reasonable as far as time. It has to be reasonable as far as geographic scope. Now, it depends on the kind of interest we're talking about, but let's say we're talking about a former employee or independent contractor. The courts in Florida will generally enforce time that's 2 years or less. So you can't have a restricted covenant for, let's say, 20 years or something like that. 2 years is generally considered enforceable in a reasonable geographic area. Let's say if you have a brick and mortar business, maybe 10 miles around the area. If you're doing another kind of business, it could be in any area that business operates, which can get kind of complicated, but that's generally what the courts will enforce. The most kind of restricted covenants are dealing with independent contractors, employees, agents, that sort of thing. There are also other ones dealing with franchises and dealers or dealing with the seller of a business. Let's say you sell your business. You sell the corporation or you sell the business, you can have a restrictive covenant, meaning a non-compete there. Those are usually enforced a little bit longer. Sometimes the courts will enforce it up to 7 years because you're selling a business. Let's say you had a hard-earned business, you're selling it. You don't want the person that's selling it. You'll be the person buying it. You don't want the person that's selling it saying, hey, I sold you my business for so much money. Now I'm going to open a competing business across the street. Let's say you have an ice cream shop and you work hard and you sell it for $50,000. You don't want the former owner to say, hey, I'm going to open up an ice cream shop across the street and compete with you. That is not going to work. And those courts will usually enforce that. So now, this is one area where Florida is a little bit unique. In determining the enforceability of a non-compete agreement, the courts in Florida, under the statute, are not allowed to consider any individualized economic or other hardship that might be caused to the person who signed the agreement and the enforcement is being sought. Some states have it where if you really need the money to live, the court will lessen the agreement. But in Florida, it's a strict agreement that the court is not allowed to consider. You can't tell the court that, hey, I need to pay my rent, I need to pay my credit card bills, etc. The court's actually not allowed to hear that. One thing that the court is allowed to hear that is a defense is that the person trying to enforce it is no longer in business. So let's say there's a restricted covenant. Let's go to the ice cream example. But the first ice cream shop that was purchased closes. So the person that owns the closed shop cannot enforce it against the other person because there's no business interest to protect. So think about that. And also the courts always consider public health, safety, and welfare. If it's an emergency situation, like we are right now in the COVID-19 epidemic, a court will consider that the public good comes first. If we need this business, making masks, making sanitizers, healthcare, the court will consider that to not enforce the agreement or maybe hold off on enforcing the agreement. So Again, the big thing is the legitimate business interest established by the person that's seeking the enforcement, and that is the thing that the court is going to consider. Now, the Florida statute also has the ability to issue what's called a temporary and permanent injunction, which is basically saying you can't do this or you can't do this. An injunction maybe to stop a person from working somewhere, an injunction maybe to close a business. That is something that the court definitely has the power to do, to issue an injunction. Also, the statute provides that the prevailing party, meaning the winning party, gets their attorney's fees paid by the losing party. So that's even a more incentive for people not to breach these agreements, because if they breach it and they're found to breach it, they're going to be paying the other side's fees. By the same token, if you're trying to enforce an agreement you really shouldn't have a right to enforce, you're going to be paying the other side.
Ron, I have a
other
question.
side's attorney's fees. Yes.
I have a question. So let's say you have some youngster coming out of school, or somebody, with everybody that does a lot of career changes these days. What industries would you say use non-compete agreements in their industry pretty typically?
Well, typically it'd be industries that deal with customer lists. Let's say, for instance, like a list that's maybe a real estate agent that has a list of customers. I've seen it be enforced by a pest control service because they have a list of customers that they use every week and they don't want anybody taking their customers. Anytime where you're dealing with a list, it's not usually used in for the frontline workers in, let's say, a fast food store or a grocery store or something like that. It's usually somebody that has contact with the customers. Let's say you're selling alarms, house alarms, and the company's giving you this list of people to contact. A lot of times those kind of companies will make you sign a non-compete agreement.
Okay.
Residential alarm companies will do that, huh?
I've heard that, yes. Yeah, because they say we took all this time to develop this client list, and you work here. We don't want you going to our competitor, because non-competes are not only do you open your own business, but they prohibit you from working for the direct competitor. Let's say you work for Company A, Company B does the same thing. You sign a restricted covenant, so you're not going over to Company B with that customer list in your back pocket.
Yeah, I can appreciate that. I will tell you this, which is interesting, okay, and I know we'll probably touch on it, but these are just things that are coming to mind right now.
Sure.
Many years ago, when I first moved to Florida in 2002, I never really saw too many do not compete clauses. But boy, when I came to Florida, and I came from Arizona, they were popping up like flies. And my dad once told me, you sign too many of these things, you're not going to have any place to work. So you really got to be careful of these things. In fact, I think I had signed one back in Michigan for a home improvement company, but it was different because Saginaw, Michigan versus the Metro Detroit area were about 2 hours away. And I knew that the company that was up in Saginaw would never be able to compete in Metro Detroit. It was a window company, a high-priced window company, but then back in Metro Detroit, there were a million of them, so it was different. But when I came to Florida, these things were popping up all over the place. So when you live in a state like Florida, which is considered a right-to-work state, how enforceable are these non-compete clauses?
They're really quite enforceable, and that's one thing that people just don't understand, that it's a right-to-work state, but these covenants, whatever lobbying was done, I don't know, but the legislature wrote a specific statute dealing with this in Florida, and that's why they're rampant in Florida. They are enforceable, and a lot of people think, well, they're not going to enforce them, and the courts do enforce them. I've seen litigation go on for quite a while on these, and the court will enforce them as long as they're reasonable, couple years, 25 miles, something like that, but they will be enforced.
Ron, I want to share a little story. My first acknowledgement or even knowledge of the non-compete agreement happened when I was a kid, and we were watching TV, and I'll be honest, I used to love watching the weather. Not that I don't anymore, but I almost wanted to be a weather person. But
wow.
When one of the local media weathermen left one station, and we're all like, why? Well, he actually went to a competitor, and so he had to be off the air for a period of time because of this non-compete. And that's where I first learned about non-compete agreements.
Well, it's amazing how you talk about that, because I had a guest on our broadcast on a different network named Jay Crawford, who actually worked at ESPN, and he had to sign a non-compete for a while. So, and I bring up Jay, and I'm still friends with him to date, and he wasn't able to work for a while, but I guess ESPN paid him a decent amount of money to stay away. So he worked, Cleveland Browns preseason games, but I think he resituated and he's working for the local affiliate out in Cleveland. But how often are they in media-related businesses?
Well, you both gave the perfect example of the use of a non-compete. Media-related businesses where there's a substantial following, because whether you're a host or you're a meteorologist, you're going to get a following that aren't really always there to turn on, the station, whatever station it may be. They're there to see the person. So if the network, the station, whatever it may be, puts time and energy to get a following, they don't want you just leaving and going to a competitor. You think if you're a hot property, and other stations are going to woo you to come over. So they are very, very, far as I know, very, very popular, rampant, and used in the media just for that purpose. So, the person will have to make, the talent will have to make a decision. Do I want to leave where I am now? And sometimes they'll have to be off the air for a certain amount of time. And can they sustain themselves, or will the new employer even compensate them while they're not on the air? Because there is an issue. Is if the new employer interferes with these, they can be brought into the litigation as well.
So they
certainly don't want to do that.
So you're telling me, in a lot of cases, a way to avert these things, whether you like it or not, is really relocation.
Yeah, it is, because these have to be reasonable to scope and duration. So sometimes you would have to relocate out of town. Now, when you're dealing with a national entity, like you're talking about ESPN, then you're in a whole different ballgame, because you're going to have to be off the air for a while. But if you're a local talent, sometimes you relocate. Sometimes, you go from one state to the other, and you know better than I, Scott. People in the media bounce around all the time.
Yeah, there was a situation. Oh, yeah, don't I know? I'm one of them. Believe me, I'm definitely one of them. You really hit this example real close to home. Now, there was a situation where when I first got my 215 license, I looked into some health insurance jobs, and I looked at the agreement. And I looked at this thing like a fine-tooth comb, and I saw do not compete I did not like. I showed this to Candy, and believe it or not, another guy was in health insurance, signed it, and I told this guy, I'm not signing this agreement. I said, what makes you think that if you don't like me that I can't work? Well, I'll let you get off. I said, no, you won't, because I'm not going to accept your offer. What, did he think I was cotton picking stupid? Maybe he did, but I know another guy that got burned by the whole thing. And to a lot of people, when they look at these no-compete agreements, really don't care, that they just stop reading and they sign them anyways, realizing what they're signing. Because I know that in this particular instance, I just told the guy, I said, you know what, thanks, but no thanks. I am not going to sign this. I have a feeling this will be a document that haunts me for quite some time.
Scott, you're exactly right. You hit that nail right on the head. A lot of people either don't read them, skim through them, and say, "Hey, I don't have to worry about this. I love this job. This is where I want to be," and they sign them, and they very much regret that day. And they'll come and they'll talk to a lawyer and say, "Hey, I didn't really read this, and it doesn't really matter." And what you said was key. With the employer says, "Don't worry, I'll let you out." Well, the court is not going to listen to that. It's what's on the paper. So, read these carefully, have a review by a lawyer, and tell, if they want you bad enough, they will make it reasonable. Because once you sign them, you're locked in.
Yeah, that's a good lesson for all those folks listening to the broadcast. Read these documents carefully, or they will bite you, and they will bite you badly.
So Ron...
Oh, yeah.
Ron,
a long time.
As a lawyer, do you charge if somebody wants you to read over one of these documents for them?
So usually contract review, you do it at my hourly rate, depending how long the contract is. It could take a half hour, an hour, maybe 2 hours to read it. And, of course I'm biased, but I think it's money well spent, so you know what you're signing.
Oh, yeah. It's just nice to know up front for anybody that would be, wanting to do that. It's actually very advisable because in the long run, if you don't and you signed it, you could have, like you said, if you lose, you can be paying for court costs, which would have paid for your fee probably a couple times over.
Oh, absolutely. I mean, if you get into a full-fledged litigation, you can be spending thousands of dollars on attorney fees, and even if you win, you might get reimbursed, but if you lose, you'll be paying their fees. I think it's well advised to spend a little bit of money and get it reviewed, at least to know what you're going into. Hey, if you like it and you still think the job is worth it, fine. But it's better to know what you're getting into, because in the law, we always say it's easy to do something in the beginning. It's really hard to undo it back on the back end. And
it's kind of like an insurance policy. If you think about it.
That's exactly true, which is something a lot of people don't read again.
Right.
I think people are under the impression that they have no bargaining power with these kind of things, and that may be true to an extent, but you can always, sometimes like in Scott's case, it really was not worth that job to be stuck like that. Sometimes the employer will change the agreement, sometimes they won't. And if you make an informed decision, say, look, this job is great, it's what I want to do, the pay is great, and I'll sign it, that's fine. Just know what you're getting into. That's my only suggestion. Just know what you're getting into, like any other contract you sign.
So what would you say on an average? I'm asking what your fees, but what would you say the average client or would pay, about $200 an hour or a half an hour? I'm just trying to get an idea numerically what somebody can expect to spend on the front end, because we know you already indicated thousands on the back end.
Oh yeah, I would say just as an estimate, depending on what your attorney charges, I would say a few hours worth of work. So I would say probably somewhere between $500 and $750 to get a contract reviewed. Of course, depending if it's longer or shorter, but I think that's a general ballpark. Most lawyers now charge, at least in our area, somewhere between $350 and $500, depending on who you go to.
So
it's still worth calling. So hey, and you can always call around.
Oh no, that's for sure. I mean, believe me, I understand that. But a contract review, you say $350 to $500, but some of them will get as much as $700. Hey, listen, you know what? That's a drop in the bucket considering what 2 years worth of compensation would cost you if you make the wrong mistake, and then you can't do anything except become a telemarketer or wash dishes or do a menial job that you don't want to do. Am I picking on those professions? No, but they're the first things that came to mind, so whatever.
Well, yeah, it's the old penny wise, pound foolish then. Yes, it's worth to spend a little money. Right, it's dealing with your livelihood. And hopefully, if you're signing a non-compete, the compensation is at least good enough where it's something to think about, because these agreements aren't used in a lot of jobs because you don't have anything to compete against. So, like anything else, if you're a professional and you want to get what's best, you're going to have to pay a little bit.
Would you say home improvement companies are another example of potential no-compete headaches?
Yes, I would, because if you think about it, that's a perfect example, because those have client lists. They have either lists that they want you to solicit or lists of past customers. So they're going to want to lock you in. They don't want you competing against them, because now, from the other perspective, you own the business. The last thing you want to do is hire this new person. They work there for 6 months, and they take your client list and sell it to your competitor. So yes, those kind of jobs, 100%. That would be a perfect example of a business that uses a non-compete agreement.
Yeah. Now, the one thing I should say about home improvement companies, and this is from another lifetime ago, is it is a big ticket item. Okay, and anytime you have a big ticket item salesperson that can make a lot of money per sale, whether they would come back for another thing or not, let's not kid yourself. Was it so much taking their list, or actually going to a competitor where you can actually bite them in the backside, to me, that's where you have to draw that line. Where am I trying to keep them from my top competitor more so than taking the list? If you know where I'm going with that.
I think you're right, and I think a lot of the companies have that in mind when they even have these agreements drafted, because they know who their competitors are, and they know their competitors' tactics. They don't want their top salespeople or any salesperson going to their competitor. Right. Exactly right, and sometimes that's what it is. It's not only the issue of you, meaning you, the employee, opening up your own business, opening up your own home improvement shop. They're really thinking about going to their competitor down the street who they probably ate anyway.
Precisely my point.
So, Ron, I have another question. So, as an industry, would you say that there is an industry that more non-compete arguments are brought to court? Is there a certain industry that does that more? Do you know?
That's a tough question, Andy, but I've seen varying industries. I think the ones that are more that are people would generally bring to court are industries that say, well, this isn't really a big deal. Anybody can do this. Let's say a lawn mowing service or a barbershop. I've seen those where look, I cut hair, but is that really, you're going to stop me from cutting hair because I signed a non-compete? Something like that. It really depends. Or something there's a lot of money involved. Let's say you're a top salesperson and, company A is paying you, a good money, but company B is going to triple it. Well, maybe I'll try to get out of it. It's worth going to court to try to get out of it. It's worth taking the shot, rolling the dice, if you will. It kind of varies.
Now, come from the Metro Detroit area, Michigan, do you find that no compete agreements are common in union states? And if they are, how do you get around those if there is a way to do that? And I'm talking about union states, not a right to work state.
Right. Union states do have them. For my limited understanding on that is they're actually a little harder to enforce because those states usually have better worker protection laws that protect people working. So they're usually the courts are tougher on these agreements. They have to be really strict on what they're going to enforce. The so-called right to work state is a little bit of a misnomer because the right to work also means the right not to work. There's certain union protections that actually will actually totally get around these. If you're in a union, you're going to go under the union agreement. So sometimes it does have a benefit to work in those kind of states.
Ron, I have another question, and I don't know that you're going to know the answer to this because you obviously are here in Florida. But
I am.
I work for a big company that is in many states, and one of the states that we are in would be California. And California has all kinds of different laws compared to anybody else that I know of. And they're especially favorable for the employee. So do you know, do they have a lot of no compete in California?
As far as I know, because I don't practice there, right. As far as I know, it's harder to enforce those in California. They don't have it much in California. California is a special bird, and they have special laws that are favorable to the consumer, favorable to the employee, and favorable to everything like that. So, yeah, they're harder to enforce.
Okay.
Which brings up an issue that a lot of times you have to look at where your company is headquartered because they might try and do what's called a venue provision, meaning we're applying the law of our headquarters. You'll see in agreement, Michigan law applies, California law applies, Florida law applies. So that's also something to keep aware of. For instance, if you have a Florida company, even though you employ people in different states, you want to try to get them in Florida because it's more likely to be enforced.
Yeah, you're right, Ron. Having been to California a few times and known a lot of people there, California is definitely a different bird. It really is. And for all you folks in California, there are lots of good things about your state being a different bird when it comes to this stuff. Maybe the other parts aren't your gas prices and your high income taxes all over the place. But when it comes to these type of agreements, throw it out the window, basically, isn't it? So
Ron, do you see a lot of people that are selling their business use these non-compete?
Yes, they are used all the time selling the business, and they're actually used by the buyer, because if you spend a lot of money on the business, you don't want the seller to open up the same business across the street. So they're used almost all the time. Usually a couple of years, usually a reasonable geographic location. Let's use the home improvement company as an example. Let's say you own a home improvement company, you've worked all these years to build it up, and you sell it for a few $100,000, and you have all these customers and all these processes, and then you're working on it. You don't want the former owner to say, hey, Mr. or Mrs. Client, remember how great of a job I did? Come with my new company. Mm-hmm. So these are used all the and they are the courts will enforce that.
Yeah, very interesting. And I think the one thing folks in Florida can deal with more so than a lot of places is you have a lot of hurricane protection companies as well that would probably be potential no-compete agreement businesses as well, right? Hurricane protection?
Oh, absolutely. Those are consumer-oriented businesses that are very protective over their stuff. So, yes, they would definitely be ripe for these kind of agreements, 100%.
Yeah, well, like you said, consumer-oriented is the key here to this whole thing. And, again, it can pretty much veer off into a lot of other things.
Oh, absolutely, absolutely. So, and it kind of like we were saying before, if you're going to have an employer give you restricted covenant, you should go to your lawyer. If you are a company, either you're selling the company or you are hiring employees, a good suggestion is have your lawyer review it and draw it up. Don't pull something off the internet because you just don't know. Have your lawyer at least review it, but probably say, can you write this for me? Again, it's worth a few $100s to have something that you feel comfortable with down the road. Mm-hmm. Because that's pretty common now with all these internet legal providing companies, if you will, that you can get a form. But you have to make first, the form is good in your state. Second, the form is what you're looking for. And third, you can't customize it. So it's always good to have your lawyer. I'm not trying to pump up the legal profession, but they do serve a purpose.
Yeah, I know a lot of people will, in my industry, I know a lot of people will think that they can go online and they can just Google a document and they can use that document and bring it in. And we're like, wait a minute, no. You live in the state of Florida. There's a certain form in the state of Florida that has certain statutes that have to be on the form in order for it to be enforceable in the state. So that's a very good point that not everything you can't just get a generic form at like Office Depot or anything like that for some of these things because they're not always enforceable. So yeah, it's definitely a good thing to contact a lawyer and you can ask them, hey, this is this form I got. Can you just quick look it over and see if this is an enforceable here in the state that I live in to do what I want to do?
Ron,
exactly. Most lawyers would be happy to do that.
Why don't you go over in more detail what you consider a third-party beneficiary?
Sure. A third-party beneficiary is essentially somebody that's not part of the contract. They didn't sign the contract, but they are a benefit of the contract. Let's use, for instance, okay, you have a, let's see, expressly, I'm just looking at this. You picked it out of the statute. Good job there, Scott. A third party, let's say you have a contract. You and me have a contract, but it benefits Candy. She is a beneficiary of the contract. Let's say we own a company, but she owns a subsidiary or has a customer list or something where she is the beneficiary. Let's say I violate the contract with you. She still has a cause of action because she is the party that is the one that will benefit from the contract. Does that make sense? It's kind of a little complicated legal mumbo-jumbo, but that's essentially what a third-party beneficiary is.
Well, a lot of people are going to want to know what a third-party beneficiary is. Just because I'm pulling it from the statute doesn't mean that I people want to think that I know all this stuff by heart. I didn't pass a bar exam. All I do is bring you guys on here to talk about this stuff. Because as Marshall McLuhan would say, the medium is the message, and this is a medium, and you're giving us the message. That's the first thing that they teach in the media.
A lot of times, a third-party beneficiary will be in the non-compete itself. It will say, the contract is between you and me, but this third party, let's say Candy, she's a beneficiary, meaning she's impacted by the agreement too, which is another reason to read everything in there. Because if you see a name you don't know, you're like, who's this? Ask before you sign it.
Well, and again, I think one of the things that really helped me a while back is when I first got my 215 insurance license. Everybody's going to recruit you all day long to try to get you to work for them. But there was something about this thing that I had a bad feeling about. And I think part of it might have had to do with when I interviewed with the guy up in West Palm Beach. And I don't know what it is about the guy. I won't mention any names because I don't want to have to deal with any repercussions later. But when he went out there and made a comment to me during the interview that the guy wasn't in a sales meeting because he's an Uber driver trying to subsidize his income. And I'm thinking to myself, number one, dude, you were late to my interview. I didn't tell him this. I'm thinking it, right? And two, you're criticizing a family man for driving Uber, okay? And I'm thinking, is this the kind of guy that I would want to work for? And then I proceeded to go ahead and ask him about the no-compete. Well, come on, Ron, connect the dots, would you? Okay, somehow, some way, the sum of the whole and the whole of the sum didn't quite add up because you're criticizing a family man for driving Uber, Lyft, whatever. I know it was Uber. And now we're worried about a legal document that could be beneficial towards what we're doing, and I think that's really when you look at things and put things in perspective here, that stay the heck away from these. Again, I reiterate this when my dad and I looked at these documents and said, Scott, you won't have a place to work if you sign too many of these documents. These documents can be poisonous, okay? I would rather eat my cooking than sign these stupid documents. Although sometimes it isn't that bad, depending on what I stick in the microwave. Thank God for microwaves. I'd be in deep trouble. Okay, whatever.
Well, that example sounds like a company you did not want to work for, that's for sure.
Well, I don't know. It's all those things about red flags, and they always say during a job interview, okay, not only are they interviewing you, but you're interviewing the company. I think that anybody will tell you right now, you have to make sure that when you are doing such a thing like that, and that's where you have to connect the dots with these no-competes. I mean, but really, and I know we talked about this shortly, how many of these people really, give me a rough idea percentage-wise, 5, 10, 50% read it from the first letter to the final punctuation mark?
Oh, that's a great question. That read it from the first letter to final point, how many people? Well, I would say you're probably maybe about 20%, because there are people that will read every single word and analyze every single word, but I would say 15 to 20% max. Most people don't. They just kind of look at the highlights. Hey, I'm getting this much money. They tend to only read what they think are the good things without reading the fine print. And the fine print is where all the problems come, especially in that 9-point font or whatever's in these agreements.
So that 80% equals a certain type of pie. I'm going to ask you guys to go ahead and come up with kind of pie that I'm talking about with the 80%. Candy, take a guess. What kind of a pie?
Humble pie.
Yeah, there you go. So, Ron, humble pie. We all agree that humble pie. Oh, come on. Cheese O Pete's. Cisco's with Ron Renzy, Candy Ebling, Ron Swoboda, Stuart Ack. Humble pie, folks. That's what these 80-20 deals are.
Humble pie is the best kind of pie.
Well, yeah, I really like apple and lemon meringue, but not when it comes... Now, again, lemon meringue could apply to the employers because you're dealing with lemons, okay, but not forget the meringue. Let's get off the food channel here.
That's a good point, Scott. I like that. That's true.
We're only getting warmed up, Ron. Don't worry. We still have a meeting tomorrow over at the Wednesday Coral Springs group, by the way. So continue on about these agreements, Ron. What else should our listeners learn about them?
Well, that's pretty much it. Just be careful what you're signing. Watch what state you're signing them in. Make sure they say everything they need to say. And don't hesitate to go to your lawyer and ask your lawyer to call the company or the company's lawyer and try and negotiate. Sometimes the company will say, no, we're not changing a word. Sometimes the company will say, hey, we like you. Let's make it reasonable, and we'll come up with a compromise. don't ever hesitate, But my first and foremost thought is talk to your lawyer. Everyone has a friend that's a lawyer, don't they?
They do. So with that said, Ron, when you look at these no-compete agreements, are these documents legal if somebody were to cross anything out and they had to initial them?
Yes. If they cross it out and both parties initial it, that cross out becomes the contract. So absolutely yes. So
then you're telling me that these can be amended because of a cross out and an initial?
Yes, as long as it's agreed by both parties. Now, the person signing on behalf of the company has to have some authority. You can't get, somebody, vacuuming the carpet. But yes, as long as it's signed by a representative of the company and the other person, cross out, initial, that contract is legal, my friend.
With that being said, make sure that you get a copy of it for your records. They have it for theirs, because then if it bites you later on, then your legal advisor or lawyer or whatever, at least you'll have a basis for an argument to get you out of such a jackpot.
100%. That's always, you brought us some, is always good advice. Whatever you sign, get a copy of it, print it out, save it on your computer. Just always have it handy, because sometimes things don't look the way you think they do, and it's good to have your own copy.
Anything else you want to add, Candy?
No, I think that's extremely good advice. Always have a copy of what you've signed, because you never know what might try to come back and bite you, or have someone change it. And if you don't have a copy, how do you know which was your original agreement?
So
that's 100% true. People, you never know what kind of shenanigans somebody's gonna pull down the road.
Well, the one thing I will tell you about this broadcast, albeit we're talking about obviously the Florida non-compete agreement, but I don't care what part of the country you're in. This broadcast is designed to make sure that everybody in all 50 states, or I always say 51 because you got state of confusion, because that's what these things are anyways. A lot of people used to think Washington, D.C. was 51. Puerto Rico was never granted statehood, so we can't really quite count them. But, state of confusion, folks, is what these non-compete agreements really are. So my advice to you is, I don't care what state you're in, read the agreements and make sure you definitely get whatever legal advice you can to avoid getting into a jackpot that you don't want. Jackpots are okay to be won over at the casino, but you don't need the kind of jackpot that will cost you deep into the checkbook for sure, because I don't care. PayPal won't dig you out of that one. So any closing thoughts here, Ron, before we let you go ahead and give your contact information? Just to let everybody know, you're listening to the South Florida Tribune podcast. This broadcast can be heard on Apple Podcasts, Spreaker, Spotify, iHeartRadio, Google Podcast. And I'll repeat that again for our listeners. You can hear this broadcast on Apple Podcasts, Spreaker, Spotify, iHeartRadio, Google Podcasts, or wherever you get your podcast. So any other advice you want to offer before we ask you to give your contact information, Ron?
Well, Scott, I think we covered it. Read everything you sign. Keep a copy of everything you sign. And have your lawyer on speed dial, because you never know when you need her or him. Like I said, my firm's name is Wahlberg and Renzy. They can be reached at 954-757-1212, 954-757-1212, or email us at info@wahlberg-renzy.com, WALBERG-RENZY.com. On Twitter, we're at Wahlberg Renzy PA, and Instagram, we're at Wahlberg Renzy.
One last thing. Don't forget, everybody, that you can find a sample of one of these non-compete contracts on southfloridatribune.com, and it'll have Ron's contact information there in case you need to have him review any of yours that you're thinking about signing.
And I should also point out that Ron Renzy is our legal analyst for the South Florida Tribune, so if you want to go ahead and contact Ron, you can do so through the South Florida Tribune as well. So with that said, okay, let me give our contact information before we close out the broadcast. You can reach us on Twitter with the @ Tribune South, Facebook South Florida Tribune Gets It Done, Instagram South Florida Tribune Gets It Done, YouTube channel South Florida Tribune Gets It Done, website www.southfloridatribune.com, email address southfloridatribune@gmail.com, and of course you can reach me at LinkedIn, Scott Morganroth. You are listening to the South Florida Tribune podcast with Ron Renzy and Candy Ebling. Ron Renzy, by the way, will also be when COVID-19 gives him the peace of mind that we can drag him here into the studio, will also be participating on the sports side of the broadcast as well. One of Ron's passions happens to be auto racing. So anytime I come up with an auto racing thing out there, he's kind enough to go ahead and share it with a lot of his followers. So Ron Renzy, actually, one of his great acts on the sports side was when we did a broadcast together involving Sebring International Raceway, when we had Ken Breslauer, the PR guy for Sebring International Raceway. So Ron's passion is endurance racing. So for a lot of you folks that want to know a little bit about Ron Renzy, there you go. And, of course, I also work with Ron Renzy, the Coral Springs Regional Chamber of Commerce. Ron has been a really great sounding board to me anytime I run across situations that we have to run through the network as well to make sure that everything is kosher and that we do the right things and deal with compliance. And that's the one thing that's important when you're talking to a lot of different people is compliance, compliance, compliance. So, I talked to Ron throughout the week, and I'm glad that you're a very big asset here with the South Florida Tribune and everything that we stand for here on the network. Any closing thoughts, Ron, before you and I get to do this bad boy on Zoom tomorrow with Shirley Klein and company?
No, Scott, I just appreciate you working with me, and I do appreciate your calls, and I love working with you and the show. And Candy, thanks for putting up with us.
Hey, it's my pleasure.
And just so you know, the South Florida Tribune podcast featuring Ron Renzy does appear here on the network, WSAN Network, twice a month. So if you have any suggestions or questions for Ron Renzy, you can contact him through his contact information or the contract information that I went out there and provided as well. So on behalf of Candy Ebling and Ron Renzy, my name is Scott Morgan, Route the Motor City Madmouth. Thank you for joining us here on the South Florida Tribune podcast. And until the next time. But meanwhile, before we sign off, I want to ask everybody out there to mask up, be safe, social distance, and also kudos to our front line heroes, doctors, nurses, because we really depend on these folks to try to keep us safe and healthy. And I know this is a very adverse time in our country right now, but we need to keep it together and do the right things. Do not go out there and take this virus lightly, because I'll tell you what, not only the numbers here in the state of Florida high and around the country, but this virus will kill you. So once again, on behalf of Ron Renzy and Candy Ebling, my name is Scott Morgan, Route the Motor City Madmouth. Thank you for joining us. We will catch you the next time on the South Florida Tribune podcast.